Got it. Yeah, just
Okay, good afternoon, everyone. This is a final plea calendar for August 9th. If you are on this calendar, today is the last day that you can enter a plea if you're interested in entering a plea and have the right to withdraw that plea if the sentence you get is worse, less desirable than the sentence your lawyer asked for. So if your lawyer asks for 2 years probation and you get 3 years probation, you can, with no questions asked, withdraw that plea. And we move your case to a trial calendar. You're not required to enter a plea today. Your next stop is a trial calendar, but any plea entered after today in your case will be one where you do not have the ability to withdraw your plea if the sentence that you get is more severe than what your lawyer asked for. That's the significance of final plea. With that, we're going to work our way down the calendar in the order in which it was published. Position 1 is State versus Bradley. Is Mr. Bradley here?
Judge, I expect him on Zoom, and if we could come back to this one, I anticipate a resolution today.
Okay, we will come back to it. Mr. Peoples, is it your sense, assuming Mr. Bradley shows up, that this case is resolving?
Yes, Your Honor.
Okay, we'll hold for Mr. Bradley's appearance. Position 2 is State versus Ogbamudia. I know she's here. I saw her before. Ms. Feely, I very briefly interacted with your client before you got here just because we were wrapping up drug court. She's formerly of drug court. So I said, hey, and assured her that you would be here and we would get an update. What are we doing with your client today?
I expect a resolution today.
Okay. Do you want to talk more with her and with Mr. Peoples, or are we ready?
I think we need a little bit more time, but.
Okay. Sounds good. Well, moving right along without actually having resolved any of the cases. Position 3 is State versus Charlie Neal. Mr. Neal is here.
He's my judge. I have a new offer, so if we could come back to this one as well.
Got it. Mr. Peoples, these offers are coming in kind of late. I know it's chaotic outside, but that doesn't affect what's going on in your files.
That's correct, Your Honor. And Attorney Wood and I have talked multiple times about this case. So I sent her over a new offer that I think would entice a resolution.
Okay, I appreciate that. It's just having the offers come a little further in advance means that then lawyers can talk with their clients in advance. But we've got time this afternoon, so we'll see what happens. Position 4 is State versus Morgan Villa or Villa. And I see Mr. Melnick.
Good afternoon, Your Honor. She's on the Zoom call as well. I see her name. She has a special needs child. There she is.
Hi.
Right now,
can't
Judge,
hear.
I can't hear you. Still, can you hear? No.
Mr. Melnick,
Yeah, they can
can you
probably
hear him?
I can hear
Okay.
you.
Okay.
I believe they are working on it.
Gotcha. Okay, is this Ms. Rivers?
Yes.
Okay, so people on the Zoom can hear us right now. Maury.
We're the special people on Zoom.
We're going to come back to that case. And let's turn to position 5, which is Darnelte Russell. I see Mr. Muhammad is here. Who's handling this for?
Judge, we can hear now.
Well, that was amazing. What happened?
I don't
Yeah,
know.
I can hear you fine now. She just turned her camera off, but I'll tell her to put her camera back on.
Well, I just called another case, so we're going to come back to, what's your client's last name?
Villa.
Villa.
Yes, sir.
In a minute. We're going to handle Mr. Russell's case right now. And you are? Ms. Long. And are you filling in for?
Casting call for the next 2 weeks before ADA Freshens Marsh takes SAU caseload for your courtroom.
Okay. You're in charge of the state's handling Russell's case. Mr. Muhammad, what are we doing today with Mr. Russell?
I'd like to request a continuance off of this calendar. This is a rape accusation where it's basically, the facts are basically he said, she said. My client's mother is in the hospital and he got word that they're requesting, saying that he's being recommended for hospice and she has likely weeks to live. So we could end up in a situation where we call it in a trial, and literally, she could pass away that day or days before while we're in trial or something to that effect, given the news that they just got. So that's one issue. And second, given the nature of this case, it's my opinion that for a case like this to have any hope of resolving or the two sides coming together, it's all about getting to know the people. There isn't some fact pattern that a new person has to wrap their head around. It's just the person, like which person is telling the truth. And for somebody to come on board, read up on it, not really know the person, not really have time with a case like that, I think is kind of doing the process a disservice. And so for that reason also, I think it would be a good idea for this case to be continued.
So, Ms. Long, what are your thoughts about what ought to happen with Mr. Russell's case? And I get it that you are transitioning. I'm not quite clear why Ms. Hall's not here. I know she's rolling out of this role, but this transition in SAU, which is incessant, certainly not the defendant's problem, and it's becoming less and less the court's problem as well. But you're here today, so tell me what the state's announcement is in the Russell case.
I understand, Your Honor, and apologies for the disruptions. The state did make an offer in this case, it's mandatory minimum. My understanding is there's no outstanding discovery. And so the state's announcement is ready for trial. If the defense has a request for continuance based on personal health issues of his family, the state made no objections to that.
Okay. And of course, this isn't the trial calendar. Mr. Russell's case will likely appear on the trial calendar that will be published for late September, so over a month and a half away. Mr. Muhammad, I didn't hear you. I appreciate everything you said, but one thing I didn't hear you say is I'm missing discovery. It sounds like you've received everything. It sounds like this isn't a case with a lot of discovery because it's a he said, she said. Is that a fair statement? Okay. What I will do is move the case to the trial calendar it's going to be on. I am open to a motion for continuance if it is based on Mr. Russell's mother's declining health I'll need some kind of documentation because I worry a little bit that this is something that could be extended again and again, which in some ways is a great thing because it means Mr. Russell's mom is still with us. But what I don't want to do is create a scenario where we just keep rolling the case over and over again. We've got someone out on bond with serious charges, and they need to be resolved. If they're not resolved by way of a plea, then we'll get jurors in here and resolve them that way. And unless it's made real clear to me that Mr. Russell's mom stay here is exceedingly brief, he's going to need to deal with his trial. And hopefully his mom's situation continues on past that trial. But otherwise, it could be, hey, we're fortunate mom is here for another 3 months. So could we delay the trial for another 3 months? And then it's another 3 and another 3. And we're not there yet, but I have had scenarios like that arise, and I'm going to guard against it now because that just ended up not going well for anyone involved.
And what about my other concern, Judge? For someone to come and do in a case like this, I just have a concern about that. You know, again, it to me, it's really about knowing the person. And
No, I heard.
I have a real concern about that because I think we should have time. I should have time with the prosecutor. Like, okay, let's really get into this, spend time on it, that sort of thing.
Sure. So
It'll probably be 3 weeks before I can start talking. So we'll probably have 10 days or a week to try to talk about this case.
So have you and Ms. Hall already established that connection so that Ms. Hall understands or is beginning to understand the things you're describing, or that dialogue didn't start?
That dialogue didn't happen, and I guess it's prevented by this situation. It's prevented by the situation. So,
Which situation?
where it's transferred, you know, to someone else. So.
Okay. Well, it's Ms. Hall's case for the next few weeks. And so the only reason why I'm asking is this has come up before too, because of transitions. And I have found that the district attorney's office is actually pretty supportive of the notion of, I appreciate Attorney X is leaving this division or this role, but Attorney X is going to keep that one case because of a scenario you described where Mr. Muhammad and Ms. Hall have been working on it a lot together. There's some moving parts and there's personalities and this and that. And the DA's office has been pretty good at saying, I know DA X, you're moving over here, but this one case you'll keep to maintain that continuity.
If that's the case, where, you know, for the next few weeks, we can possibly see if there's some breakthrough, then that would be fine.
Well, but it sounds like you and Ms. Hall haven't started that dialogue. And if you haven't, then that leads to my next suggestion, which is start the dialogue with Ms. Marsh, because we know where the case is going to end up. Ms. Long is just, she got the handoff and she's going to pitch it real soon. But Ms. Marsh is where it ends up. So if this is going to be a trial, whether it's in September or October, because I'm going to keep putting it on trial calendars. If it's going to be a trial, it's going to be Ms. Marsh. And so I'm happy to send an email copying you to Ms. Hall and Ms. Marsh saying, here's this case. It didn't resolve at final plea because the state's offer is 25 years to serve, no parole. Mr. Russell's not interested in that. I respect that. I'm going to ask that Ms. Marsh, you engage with Mr. Muhammad and don't say, oh, I'm still in Judge Adams' courtroom doing these things, because this will be your case. It will be on the September trial calendar. And so I need you now to start working with Mr. Muhammad so that you can begin investing in that type of communication that you want. Now, if what I get back from the DA's office, and you'll be on the email chain, is nope, we won't do that, then we do need to move the case on that basis. But more fundamentally is your client's mother's situation. And if we need to move it once, because the doctors say there's 3 weeks left. That's what Mr. Russell should be focused on, is being with his mom for 3 weeks. But if what the doctor says is it's complicated, it doesn't look good, but it could be months, then months is what it will be. And we're going to resolve Mr. Russell's case, whether it's a plea or a trial. And so you don't need to disclose anything that Mr. Russell doesn't want to disclose about his mother's health. But if you disclose nothing, then that's not going to be a basis for a continuance. And it can be ex parte. You don't need to share it with the state because they're not the ones who grant the continuance. I do. But if there is reliable medical information that says there's this very, very small window that remains, like you, I want Mr. Russell to be there with family and his mother. But if it's something different, which is it's not happy news, and I'm repeating myself now, but it is a window of 6 to 12 months. I'm not going to defer a case out 6 or 12 months. So let me know about that. In the meantime, I'll do the email to Ms. Hall and Ms. Marsh saying, here's this case, Ms. Marsh, I need you to commit to engaging with Mr. Muhammad now. And if they can't support that, I'll be frustrated, but I can't order it. But I don't want that to disadvantage your client, that they're unwilling to have the handoff work that way. Okay. All right. Ms. Long, anything else you want to say as the unlucky intermediate player in this?
Other than that, I intend to also send an email to Ms. Marsh just to put this on her radar and make sure that they can start.
I will take care of that.
Thank you.
All right. So, Mr. Muhammad, I just want to make plain, so I'm hearing it. Mr. Russell's not interested in entering a plea to 25 years to serve. Fair statement? Okay. You've told me that you've got all the discovery, so you're good to go there. We will see you for the call of the calendar on September 20th, unless I get a motion to continue and I grant that motion to continue. And again, if it's on the medical side, it'll need to have some support that you either share ex parte or you also share with the prosecutor. And I'll connect us with Ms. Marsh. All right. Thank you. Yes, sir. Yes, ma'am. Oh, one last thing, Ms. Long, and Mr. Muhammad's free to go. So am I just not to expect that Ms. Hall is going to do anything with any of her cases for the next 2 weeks?
My understanding is that she has been moved to the domestic violence unit, and therefore, myself and my colleague are covering the courtrooms that were assigned to her for this week and next week.
Okay.
And on August 21st, Ms. Marsh is moving from complex up to SC.
Okay, so it's not that Ms. Hall is here and just not wanting to work on these cases. She's been given another workload by the powers that be, and you and someone else are having to scramble and do a little extra coverage. So if I have it's called SAU.
Yes, sir.
If I have an SAU issue over the next couple of weeks, who do I reach out to?
You can reach out to me and I can figure out what needs to happen. But for now, Ms. Marsh will be taking over on August 21st.
Right, and she's come by and we've met, and it's going to be wonderful. And I know she can't do that yet, and she's got other responsibilities. It's just there's some time between those two, and I'm trying to figure out. So is Ms. Mack with SAU or not with SAU? Okay, so you or Ms. Mack would be someone I could reach out to.
That's correct.
Okay. Position 4, before you leave, Mr. Peoples, the Ms. Vila case. Is that your case? Okay, all right. Then yes, you may go, Ms. Long. Thank you.
Thank you, Your Honor.
All right, Ms. Vila, if you would turn your camera back on, please. We're moving back one to position 4.
And Judge, can you hear me okay?
Can you hear me okay?
You fine?
Fantastic. So Mr. Melnick, do you have all the discovery that you understand to be out there?
Yes, I do, Judge.
Mr. Peoples, have you communicated an offer to Mr. Melnick that the state is prepared to make in this case?
I have, Your Honor. We spoke. I do anticipate this being a resolution short of trial, but I have communicated an offer. I don't expect to take it today.
Okay.
I believe it will resolve before trial.
Okay, what's the offer that's on the table today so that I can make sure Ms. Vila understands it? And then if she's going to say no, thank you at this time, we get all that on the record.
It's a plea to, it would be an offer to the indictment as charged, Your Honor, at this time, 15 serve 10, and a stay away from the victim.
All right, Mr. Melnick, is that the offer you received most recently from Mr. Peoples?
It is, Judge. He and I spoke about the case yesterday. This is a case that has some similarities to the previous case you had just addressed, where it's our anticipation that upon further investigation from the DA's office, that this will become a charge or a case that does not involve the minimum mandatories anymore.
Okay, but at this point, it does. And I guess you and Mr. Peoples will keep working on it as the trial date approaches.
We will, Judge, assuming that Mr. Peoples is in the same position that he's in right now. And I hope he remains there.
Able Assistant District Attorney will be there, and I'm sure Mr. Peoples will document his case file so that there's a smooth transition. Ms. Vila, do you understand what the state's offer is today? That if you were to enter a plea to the one charge in your case, the state would recommend 15 years to serve 10 years in custody, followed by 5 years on probation?
Yes, sir, I understand.
Okay, and I take it from Mr. Melnick's response, that's not something you're interested in pursuing at this time, is that correct?
No, sir.
You understand that after today, you are free to enter a plea, and it may well be that's how this case resolves. But what you will not be able to do after today is withdraw that plea if the sentence that I impose is more severe than the sentence that Mr. Melnick asks for on your behalf. Do you understand that?
Yes, sir.
I think, but I'll double check, that this case is slated to appear on the September trial calendar. Yes, it is. So if it's not resolved before then, we'll see Ms. Vila, and you'll need to be here in person, not appearing virtually, unless Mr. Melnick makes some special arrangement, of which I'm not aware right now, on
Yes, sir.
the 20th of September. You'll get notice, and more importantly, Mr. Melnick will, and he'll be talking to you, okay?
Yes, sir.
Mr. Melnick, anything else on behalf of Ms. Vila?
Not at this time, Judge.
Peoples, on behalf of the state? All right, thank you both.
All right.
Next up is Adrian Washington, and Mr. Shapiro sent me something about that. He may be one of the ones who's not allowed in the building or in my courtroom anymore or something.
He's currently away at conference, Your Honor. ADA Jordan covering.
Oh, that's right. He said you'd be here. I was like, wait, why are you even here? That's why he sent it. Let me find Ms. Nelson's email.
And Judge, I can help you out with that as well.
So it's going to be a plea. I think the hiccup, and maybe not a hiccup, just what you wanted to massage was this permanent protective order.
Yes, I do need to speak with Mr. Washington, so if we
Okay.
could just come back to this.
Great. But your sense is that it's being resolved today.
That is my hope.
Okay. And you're here to cover that, Mr. Jordan.
Yes, Your Honor.
All right. So that's another comeback to as well.
Thank you, Judge.
Sure. Position 7 is State versus Brittany Davis.
Judge, I believe we can have the final plea hearing. I believe she's on. Yes, there she is.
Ms. Davis is up there.
Hi, sorry, I was trying to get it on.
No problem. Startled me there. Let's get you on the spotlight. Okay. Can you stand still in a minute?
Yeah, I was sitting down because I'm actually in a domestic violence shelter, so I have to be in a private room.
Okay, great. And we'll make this quick, but you be right there. And Ms. Wood, you mind moving over one seat just so you're in the middle for Ms. Davis. Okay, so this is position 723 SC 187021. We'll take this down. State versus Brittany Davis. Ms. Davis, you are charged with burglary in the second degree. It's the only count in your indictment. Ms. Wood, do you have all the discovery in this case?
I have everything that the state has, Judge.
Okay, that's a better way to put it. You're not aware of anything that's missing.
I mean, there's some things that I have questions about, but I have what the city has, Judge, and we're ready for trial.
Okay, more importantly, you're ready for trial. Your concerns about discovery aren't holding you back.
Correct.
Mr. Peoples, what is the state's offer if Ms. Davis were interested in resolving the case today?
Your Honor, the state's offer would be 5 years restitution in the amount of $1,635 and a stay away from the location.
Which is what?
It's a business, Your Honor. The (4375) Baker Ferry Road.
Well, what's there?
Business, it's called it's called Southwest Plumbing and Heating.
Okay. All right. So Ms. Davis, do you understand that if you decided today that you wanted to resolve this case by pleading guilty, or what we call an alt plea, where you don't necessarily admit you did it, but you want to resolve the case, the state would recommend a sentence of 5 years probation. So no custody, but 5 years probation. You need to pay some restitution, presumably to either an insurance company or the owner of this business, and you need to stay away from that business. That's what the state would be recommending. Do you understand that?
I do understand that.
That's all you have to say, Ms. Davis.
Okay, thank you.
I'm not asking you about whether you were involved. I just want to make sure you understand what the offer is. Ms. Wood, is that an offer you've had an opportunity to discuss with Ms. Davis?
We've talked about it, Judge. Yes.
Okay, and is Ms. Davis interested in moving forward with a plea, knowing what the state would recommend? It doesn't bind you, but is she interested in moving forward with a plea today?
No, Your Honor, we're ready.
Okay, Ms. Davis, you understand that by moving your case to a trial calendar, which is your right, the one right that you're given up right now is this ability to withdraw the plea if the sentence that I impose is more severe than the sentence you're asked for. So just by way of example, in this case, say that you did say I'm going to plead guilty. The prosecutor says 5 years probation, and Wood says, no, 2 years probation. 2 years is plenty, Judge. And I say, I'm somewhere in the middle. I'm going to say 4 years probation. Today, you say, nope, no, thank you. I was willing to do 2 years probation, but 4 is too many, and you could back out of the plea. After today, you can still enter a plea, and it may be that you get a more favorable offer from the state, but you won't be able to step back from it if you don't like the sentence you get. You understand that?
Yes, Your Honor.
We're going to move your case to the trial calendar. You'll need to be here in court unless Ms. Wood gets you excused from coming to court, assuming the case is not resolved before then.
Okay.
You able to hear everything I said? I just got a note from someone saying that the audio is going in and out.
It is going in and out, but I'm understanding what you're saying.
Great. Ms. Wood, anything else on behalf of Ms. Davis?
No, Your Honor. Ms. Davis, we'll talk soon, okay?
All right, thank you.
Mr. Peoples, anything else on behalf of the state?
Nothing further, Your Honor.
Okay, thank you both.
All right, you have a wonderful day.
All right, bye-bye. So Mr. Bradley is on the call now. We'll come back to him. Looks like he's driving some big truck or something.
I'm here. I'm paying attention. I'm here. I'm listening. How
Okay.
y'all doing?
Oh, right. How you doing, Ms. Bradley? Thanks for joining us. I need you to not be driving while we talk, but we're not going to talk for a few minutes. So you find a big truck stop and pull that 18-wheeler off the road, okay?
I'm finna stop right now.
Good choice. We'll get you back on in a little bit.
Judge, that will probably be a plea. I just need to step out and call him to confirm everything.
Okay. Jacob Hippensteel.
Good morning, Your Honor. Daniel Doherty appearing with Mr. Hippensteel.
Hey, Mr. Doherty, how you doing?
I'm doing well. Your Honor, we prepared to negotiate a plea in this case.
Great. We will take that shortly. Mr. Peoples, your case?
Yes, Your Honor.
Excellent. And finally, Mr. Constantine, who I see, I think it's Constantine. He's on the screen, and I see Mr. Tevis right here.
Yes, Judge, that is also a negotiated plea. I would ask if maybe we could go second or third report downstairs and then come back.
Okay. Would you prefer to report downstairs or you'd prefer done here and then, because then you don't come back?
I prefer to be done here upstairs. The judge downstairs would prefer me to.
Who's the judge?
Person, but it's a case with a lot of moving parts. We flew people in for the plea and.
Oh, it's a misdemeanor plea, flying people?
Battery case, so.
Okay.
United States.
Got it. If we, in reverse order, so Ms. Wood, you can talk to some people. So we do Constantine and then we do Steele and then we turn to our table. And that Ms. Feely, Ms. Wood? Okay, great. Then if Mr. Tevis, you can either be at the podium or you can sit at the center chair of the defense table.
I'll stand at the podium and let them keep their seats.
All right. They're actually going to need to move anyway to go talk to other clients, but. Just calling your client's case up. Let's see. Is the indictment accurate or do they have it flipped around? Is he Mr. Constantine or is he Mr.
Constantine
Foca?
Foca.
Mr. Foca.
Yes.
Okay.
I couldn't find him at the jail for a while because they
they had him
left
on
out
a
a T, I think. Constantin.
Yeah. As his last name.
Right.
Doubly lost. Okay. Ms. Rivers, are you ready?
Yes, I am ready.
Am I coming in clear or is the courtroom coming in clearly or is it choppy?
It's copy.
All right, well, Ms. Nelson has reached out to IT. I don't know if they'll have to reset something, but if it gets so choppy that you can't take stuff down, will you us?
Yes, I'll let you know.
Thank you. All right, Mr. Foca, can you hear me?
Yeah, I can hear you.
I'm Judge McBurney. You may not be able to see me real well. That's less important. We're prepared to go forward with a plea in your case. Are you ready to do that?
Yes, sir.
You have a right to be here in court, but you can waive that right and appear remotely. Are you waiving your right to be here in open court?
Yes, sir.
Where are you right now?
I'm in the office that I work at
Right, but is that in Georgia or Texas?
in Georgia,
Okay.
in Atlanta.
In Atlanta. All right. You also have a right to have Mr. Tevis by your side so that you could lean over and ask him a question to get his real-time advice. We can still make that happen because if you have a question, I'll have Mr. Tevis step aside. He can call you on the phone. But for now, he's in court and you are in your office. Do you waive your right to have Mr. Tevis by your side?
Yes.
Okay, then we're ready to go forward. Mr. Peoples?
Thank you, Your Honor. Are you able to hear me?
Yes, yes, sir.
Will you raise your right hand? You solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can lower your hand. Will you state your true, correct legal name?
It's Constantine Foca,
And can you spell it for the record?
Constantinfoca.
Are you at this time under the influence of any drugs, medication, or alcohol?
No,
Is there a medication that you normally take that you have not been given today?
no,
How old are you?
60. I just made 60. I don't know, 60 or 61. I consider myself 61, getting old.
We'll call you today, okay?
Okay.
And what is the highest level of education that you've completed?
What is the height of the education? I haven't completed the high school, but I took the GED in this country.
Okay, so then are you able to read, write, and fully understand the English language?
Yes, sir.
You understand that you're charged with the following offenses. Counts 1, 2, and 3, you're charged with aggravated assault with a sentence range of 1 to 20 years. Terroristic threats, count 4, with a sentence range of 1 to 5 years, and count 5, possession of a firearm during the commission of a felony, which carries a sentence of 5 years to run consecutive. Do you understand those charges?
Yes, I do.
You understand that you have to plead either guilty or not to these charges?
I do. I understand that.
You understand that if you plead not guilty or remain silent and enter no plea at all, that jury trial.
I understand that.
Have you had enough time to speak with your attorney about facts and circumstances known to you regarding the charges in this indictment, including any
Yes,
potential?
I did. Yes, I did, sir.
You need any more time to speak with your attorney?
No, we talked to you last night and we decided certain things.
Are you satisfied with his services?
Yes, sir.
Counsel, do you waive formal reading of the indictment?
I do. I've reviewed it with him.
Do you waive any and all defects in the indictment, including any with respect to your clients?
For the purposes of waive any defects.
You understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court, Your Honor, the state would be asking null pros counts 2 and 3, 2, 3, 4, and 5, and reducing count 1, 12 months of probation, weapons forfeiture, and a no contact. The list.
Mr. Peoples, please repeat that for me, please.
Yes. Count 1 to be reduced to disorderly conduct. Counts 2, 3, 4, and 5 to be null pros. 12 months of probation and a weapons forfeiture and no contact with the victims to be named shortly.
Thank you.
You understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge, run those sentences consecutively, or one after the other.
I do.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty.
I do.
You understand that if you're placed on probation, any kind, that you cannot violate any criminal laws for any governmental unit or any special conditions of probation without being subject to revocation of the balance of the sentence.
I do.
Are you a citizen of the United States?
Yes, I am.
You understand that you waive any, including any mental health defense, by entering a plea of guilty?
I understand that.
There are certain rights that you give up by entering a plea of guilty, which include by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, not afford an attorney in the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond reasonable doubt, the right to appeal of conviction charges after a trial. Do you understand all these rights?
I do.
Mr. I'll pause you for a second. Again, I'm not sure what's happening with our sound system, but I'm getting input that you should stay as close as possible to the microphone. You don't need to be uncomfortable, but the closer you are, the better. I'm fine if you're seated for that.
Understood, Your Honor.
No objection.
Yeah, as a witness.
You repeat any part of that?
Just the request was stay close to the microphone.
Okay. Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yeah.
How do you plead to the charge of disorderly conduct?
Guilty.
Is this guilty plea freely given with full?
Yes. Yes.
Mr. Foca, please wait until Mr. Peoples is done with his question. So you are answering only after he said everything. Plus the court reporter has trouble keeping track of voices that speak over each other, okay?
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, I do.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court 30 days from today's date, whichever.
Yes, I do.
You understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, I do.
Understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes, I do.
Understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
I do.
Thank you. Your Honor, if this had proceeded to trial, expected to prove beyond a reasonable doubt that on July 18th of 2020, law enforcement was dispatched to a dispute call address of 215 Joseph E. Boone Boulevard in Fulton County. The officer involved spoke with a male named Polka Constantine, who was found to later be the suspect in this incident. He was inside of his vehicle, and he noticed, law enforcement spoke with Mr. Constantine regarding the incident that took place. Mr. Constantine explained that there were several males that were near the building 17 of the property. It's an apartment complex. They had been riding and revving their engines on the dirt bikes on the property and had asked them to leave. The officer spoke with the victims, Mr. Jaquan, Jahquan, Baker, common spelling, Jertavius Baker, Jertaious, who told them that they had been riding their dirt bikes in the area earlier that day. Mr. Constantine had tried to block them inside of the area. It's alleged that during a dispute that Mr. Constantine had a firearm on the victims. However, Your Honor, the state is asking to null pros the charge counts 2, 3, and 4, and 5 because for reciprocal discovery provided by defense counsel, the state does not believe that it would be able to successfully prove even if Mr. Constantine had pulled a firearm, that it was not in self-defense. There was an altercation, Your Honor, in which Mr. Constantine, we believe this is an equitable resolution. I've spoken to Jertavius Baker and
Are they brothers, the three Bakers?
they are brothers, Your Honor.
Okay.
They are, all three of them now are away at college. I cannot recall where they are. They're at separate colleges. And I also spoke with their father yesterday at extensive length after court and while on break. They're not with the resolution. However, I explained that this is the appropriate solution, and they understood.
Okay. So each of the three Baker brothers was an adult at the time? I guess we don't know that. It's not critical because this is also 3 years ago. But they're now of college age.
Correct, Your Honor.
Okay. Anything else?
No, Your Honor.
All right. Good afternoon, Ms. Jackson. Do you have any criminal history information for Mr. Foca?
Good afternoon, Your Honor. The defendant has 5 cycles. The defendant's last arrest was April the 21st, 2020, with the City of Atlanta Police Department for theft by taking a misdemeanor. There was no disposition for that arrest, and there are no convictions listed in the GCIC, Your Honor. Nothing in addition.
Thank you. Mr. Tevis.
Thank you, Judge. I'm aware of the theft by taking charge. All of these things, my client is running an apartment complex. He does the maintenance, he does the repairs, all that stuff. The theft charge was a dispute about a generator with the tenant. In this case, there was ongoing drama, as Mr. People said, with these guys running through the apartment complex. We provided video of it, flipping off the cameras, kind of just being a menace. And I think that Mr. Foca was at his wit's end with that. They allege that he pointed a firearm as Mr. Peoples. There were several officers who responded, so there was a lot of body cam. But in watching them, I said, hey, if you look at the 21-minute mark in this video, the officers asked the boys, did he point the firearm? They said, well, he was holding the firearm when he said, get the hell out of here and screw you guys, et cetera. And so I do think this is a good resolution. He probably could have handled it better, although it was not an aggravated assault. He wasn't pointing the firearm at them by their own admission in the video.
In the apartment complex, or they would come from a car and just ride through
I believe their mother apartment complex, they were not listed on the lease, which is another issue. We provided some previous history where there had been problems with the lease and tow trucks come to get the motorcycles and disputes with police about that. So ongoing about that, but they were not on the lease and should not have been in the complex, but their mother was.
Did they wear helmets?
They were not wearing helmets. These are not street legal motorcycles. They were all up and down the road and whatnot. But also there was a dispute. The motorcycle. That's where they were stored. I had many letters and complaints from the management office about the incident. Again, could have been better, but I do think this is an appropriate resolution for both sides. One quick caveat, I had discussed whether my client wanted to use first offender or not before we were taking the reduction in the charges. So I'm not sure if he still wants to do first offender since this is a misdemeanor disorderly conduct. I wouldn't necessarily recommend that, but it's up to you, Mr. Foca, whether you want to ask for first offender or not.
I would like to do so.
Okay.
Like, I don't, I never been involved in any type of crimes. I do take care of buildings, so many of them.
Okay.
It's a whole different.
You understand that if you use first offender in this case, you'll never have that option again if you were to be charged with a felony offense. You understand that?
I understand that. I don't think it's necessary. Stay away from.
Okay. So Mr. Folk still work as an apartment manager
Yes, sir.
at that same apartment complex?
Yes, sir.
Does the mother of the Baker brothers still live at that apartment complex?
No, she doesn't live. At the moment that it happened, they were under eviction. She got evicted, obvious. And she hasn't lived there for at least 3 years, close or whatever happened. After that, you know what? She was moved by the police out of the apartment. Not before she made all kind of whatever they made in there, all kind of craziness.
Okay.
That really the building software and the tenant.
Okay. But if you need to stay away from the three Baker brothers, that should not be a problem because their mom no longer lives there. So they're trespassing.
That's you're completely right. And I wouldn't want to bump into them either. That's not my.
Okay.
That's something that I don't.
Okay. Got it. Okay. Do you have any questions, Mr. Foca, about anything?
My question is about that first offender that generated that they said that I stole it.
Concern with that case has nothing.
That's. I apologize, but that was the only question that I had.
Case. Do you have questions about the plea today?
No, not at all.
All right. Thank you, Mr. Tevis. Well, Mr. Foca, there's a factual basis for your plea. We're very disorderly. Sounds like a number of people could have been charged with disorderly conduct on July 18th of 2020. That also was a long time ago. Looks like you haven't been arrested since then. I wish the Baker brothers the best in college and hope they stay focused on that. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do that. You've decided to go forward with a misdemeanor first offender plea after having a chance to speak with your lawyer, correct?
Yes, sir.
Okay, and a knowing plea just means we've talked about and you don't have any questions about this case, not about the generator case, but about this case. Is that correct?
That's correct, sir.
Okay. Then I will follow the joint recommendation and sentence you to 12 months of probation. You'll need to forfeit that rifle. How are we doing that?
The state, I believe it's already in possession of.
It was seized.
Correct.
Okay, great. Then that should be something they have a forfeiture unit and they'll deal with that. And then Mr. Foca, this is probably the most important part of your sentence. stay away from the Baker brothers. If for some reason you show up, you just need to walk away, okay?
Your Honor, all the pleasure. Stay away from that.
Mr. Tevis, can my staff sign the indictment on your behalf indicating your client's guilty plea?
Yes, Judge.
Mr. And Mr. Folka, can we put your electronic signature on the indictment indicating your first offender guilty misdemeanor plea?
How do you do that?
Can we sign for you since you're not here in person?
Yeah, okay, all right, yes, sir.
Excellent. Then I think we're all set. Last thing, Mr. Folka, you're going to get a phone call or an email or something from Mr. Tevis about how you're going to meet up with misdemeanor probation. And you'll need to follow his directions because misdemeanor probation will send me a warrant for you, which I will happily sign if you ignore the directions. So in the next couple of weeks, you're either going to need to go to their office or talk to them on the phone or something so that you get signed up for probation. Understand?
Yes.
Okay. Mr. Tevis, just work with Ms. Nelson on that, and she'll get you the contact information, and then you and they can take it from there.
Perfect. Thank you, Judge.
All right, Mr. Peoples, anything? Mr. Tevis?
Nothing further, Your Honor.
All right, Mr. Folka, you are free to go.
I'll talk to you.
Thank you, thank you.
Let's do Mr. Hippensteel. Mr. Doherty, tell me what's easiest for you in terms of standing, sitting. I need you near a microphone. Okay.
Actually, I have a scooter with me today. It makes life a little bit easier than crutches.
Excellent. If you can be at the podium with your client, that's great. Otherwise, I'm happy to give you defense counsel table.
I'm completely
You're good?
fine here, Your Honor.
All right, we're going to be hearing more from your client anyway, so we'll get him there. And let's get Mr. Folka off. There we go. Ms. Bradley, Ms. Wood will be calling you if she hasn't called you yet. You just stay off the road and we'll get to your case soon, okay? All right.
Yes, sir. Thank you.
Sure. All right. Same rules, Ms. Rivers. If you cannot hear us here, just holler and we'll pause. I have not seen IT. They must just be super busy today or they can't make it through all these barricades. This is position 8. It is State versus Jacob Hippensteel, 23 SC 187050. Mr. Hippensteel, you are here because your lawyer said you're prepared to enter a plea. Is that correct?
Yes, Your Honor.
Okay. Mr. Peoples is going to put you under oath in a moment. Once you're under oath, make sure you answer his questions and mine truthfully and completely. And just as importantly, please let your lawyer or me know if you've got questions of your own. If you don't understand something someone says, or it's just not going the way you thought it was going to go, we should pause to make sure you understand what's going on. Okay?
Okay, Your Honor.
Great. And make sure you speak up into the microphone when you're answering so Ms. Rivers can hear you. Mr. Peoples.
Thank you, Your Honor. Will you raise your right hand? You solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can lower your hand. Will you state your true, correct, and legal name?
It's Jacob Isaiah Hippensteel,
Can you spell it?
Jacob Isaiah Hippensteel.
Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, sir.
Is there a medication that you normally take? Excuse me. Is there a medication that you normally take that you have not been given today?
Not at this time.
How old are you?
I'm 30.
And what is the highest level of education that you've completed?
High school.
You graduated from high school?
Yes.
Okay. Are you able to read, write, and fully understand the English language?
Yes.
You understand that you're charged with the following offenses: counts 1, 2, and 3, aggravated assault, which each carry a sentence range of 1 to 20 years, criminal damage to property in the second degree, which carries a sentence range of 1 to 5 years, and obstruction of a law enforcement officer. I believe it's misdemeanor obstruction, which will be up to 12 months. That's correct. Do you understand
yes.
that?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that? Do you understand that if you plead not guilty or remain silent, and enter no plea at all that you may receive a jury trial?
Yes,
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Do you need any more time to discuss this case with your attorney?
I do not.
You're satisfied with his services?
Yes,
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Mr. Hippensteel, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be, Your Honor, we will be asking that counts 1, 2, and 3 be reduced to simple assault. Count 4 be reduced to a criminal trespass, and count 5 be null prost. You understand that?
yes,
You understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
yes, sir.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have a right to withdraw your plea of guilty.
Yes,
You understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the entire balance of the sentence.
yes,
Are you a citizen of the United States?
I am.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty.
Yes,
Do you understand there are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal a convicted of these charges after a trial.
yes,
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
no,
How do you plead to the charge of count 1, simple assault,
guilty,
count 2, simple assault,
guilty,
count 3, simple assault,
guilty,
and count 4, criminal trespass?
guilty,
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
yes,
Do you understand that you have only a limited right to appeal this guilty plea conviction?
yes,
Do you understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
yes,
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of your guilty plea?
yes,
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea?
yes,
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself?
yes,
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on May 29, 2020, at 100 CNN Center, officers were dispatched to a crowd outside of the center. The defendant was approached by law enforcement, and it's alleged that he threw rocks and a piece of glass at the officers and at the building. The defendant was then apprehended. Counsel, do you stipulate there's a factual basis for this plea?
We do.
Thank you. That's all from the state, Your Honor.
Can you put this in any historical context? Was there something going on May 29th, 2020?
Your
This
Honor,
sort of sounds like a riot or something. Why are people throwing rocks at CNN Center?
it says, Your Honor, I do imagine it is around that time. That there
George
was-
Floyd.
Correct, Your Honor. This was at the CNN building during the protest. He had actually gone out and he was going out unrelated to it and got kind of caught up in the crowd. The entire crowd was throwing rocks and glass. It just so happened they happened to arrest Mr. Hippensteel out of the crowd. He still kind of contends that he wasn't throwing glass, but he doesn't have much memory of it. But based on the evidence and the deal that we have, he's got no criminal history. So we're looking at just doing a first offender with 12 months probation to resolve this matter and get it behind him.
Okay.
Additionally, Your Honor, I attempted to reach out to the law enforcement officers who were at this time, I've been unable to make contact with them.
Okay, this would be the Ryan Jones and Cody Boydston and Eric Clanton. It's an odd indictment because it doesn't, oh no, I guess just Ryan Jones is the one officer because that's the obstruction of law enforcement officer. I guess the other two, I don't know if they're law enforcement, but the only one who's listed in the obstruction count is Ryan Jones. There's something about a skateboard, using a skateboard to hit the window of the CNN Center. Did you have a skateboard with you? Do you at least remember that?
Yes.
Correct, Your Honor. And this is kind of where we came into the criminal damage to property. The window had already been shattered, and then he did hit it with his skateboard. But I had this discussion with Mr. Peoples. How can you have criminal damage to property if the property is already irreparably broken? So if the window is already broken and you knock another piece of glass off of the window, did you break the window if it was already broken? And that's the discussion we had with Mr. Peoples, where we arrived on the criminal trespass. Even though Mr. Hippensteel was on public ground, he was on the sidewalk and never set foot into the CNN Center.
But it's possible his skateboard entered as it hit the window and whatnot.
Right.
And certainly
skateboard crossed by 5 or 6 inches over to the cross of the window.
Got it.
But our thought was that you can't break a window that's already been broken.
Sure, you're not helping the window or calming the scene.
You could actually say he was helping the replacement because they have to remove all the glass before they can put a new one in there.
Yeah.
So if you wanted, if I wanted to make the argument that he was helping, I don't really see it going far.
No.
But like I said, the window was already broken. He got caught up in a huge crowd of stuff. He wasn't the one throwing objects, but especially without the officers being able to reach. But with the first offender, we feel that that's probably a more expedient option rather than trying to take this to trial.
Ms. Jackson, what criminal history information, if any, do you have for Mr. Hippensteel?
He does not have any prior arrests on file, Your Honor.
Thank you. Mr. Hippensteel, I need to talk to you about first offender real briefly, and then I'll see if your lawyer has anything else he wants to add. It's primarily an opportunity. If you successfully complete your sentence, then this is not a conviction. It's actually not a conviction to start with, but it remains not a conviction, and you can get it sealed, expunged, all sorts of good things. If while you're on probation, there are no significant issues. So it's a chance to keep your criminal history clear. And you're entitled to that because you don't have a criminal history, and everyone, other than if you're charged with murder or something like that, can seek first offender if they want it. It comes with a risk. If while you're on probation, you get in trouble for something else, not only do you have that new case, whatever it is, but you can have your first offender status taken away and you can be resentenced as a misdemeanor. In this case, there's not a whole lot of room that I'd have to move in, but it still would be 4 misdemeanors. And if you stack that up, that's 4 years, 48 months. So there is some exposure there. And I share that not because I think you're going to have any issue, but I need to make sure you understand the risk or the potential downside of a first offender sentence. Do you feel like you understand the benefit of first offender as well as the risk?
Yes.
Knowing those things, do you want to be sentenced as a first offender?
Yes.
Okay. Mr. Peoples, I must not have written it down. Tell me what I appreciate everything is being reduced to a misdemeanor and count 5 as being null prost. What is the recommendation?
It will be 12 months probation, Your Honor.
So it's all 4 counts running concurrently?
Yes, Your Honor.
And any conditions of probation?
Completion of an aggravating course.
Got it. And you may well have said that. I didn't get
I think I've been missed, Your Honor.
down on paper. Okay. Since this is supposedly negotiated, Mr. Daugherty, is that your understanding?
Correct, Your Honor. Our only addition is we would ask the probation terminate if possible upon completion of all requirements.
Okay. Mr. Hippensteel, do you have any questions about anything we talked about or anything you want to add to our discussion?
Not at this time.
Are you working?
Yeah.
What do you do?
I build pools. I do a lot of work in the community and stuff. So
Build pools like you dig a hole or you pour concrete, or what is it you do?
So I do a lot of driving, transporting equipment, product, talk to customers sometimes. I clean pools, pretty much whatever I'm needed to do. It's a really small family business, so.
Is it your family business or someone else's family business?
It's somebody else's family business.
How long have you been a pool person?
5 years, I believe.
Okay. What happens in the winter? Because there's not so much going on with pools then.
Just try to stay working. It's difficult, but hope for the best, expect the worst.
Do you, meaning the company tries to stay working or you do a different job in the winter?
I just try to stay working with the company.
Okay. All right. Mr. Doherty, was there anything else you wanted to add?
No, Your Honor, I think we pretty much said it before. Like I said, he did not intend to go out and, do this stuff. He got caught up in the moment along with, several hundred other people. It just so happened that he stood out in the crowd because he had a skateboard. And that's kind of what happened. Like I said, he's got no criminal history. And we would just ask that the court grant his first offender and, if possible, suggest termination of probation after completion of terms.
Okay. Mr. Hippensteel, I find there's a factual basis for your plea to a bunch of counts of simple assault and 1 count of criminal trespass. I also find that your plea is knowing and voluntary. No one's forcing you to enter this plea and you've understood the things we've talked about. Do you agree with that?
Yes, Your Honor.
Okay. Mr. Peoples, do you authorize my staff to sign the indictment on your behalf?
Yes, sir.
Mr. Doherty, can we do that for you?
Sure.
And Mr. Hippensteel, can we put your signature electronically on the indictment?
Yes.
Okay. I will sentence you on all 4 counts, all of which have been reduced to misdemeanors, counts 1 through 4, to 12 months probation. I'll have them run concurrently with each other. Count 5 is being dismissed. The one special condition of your probation is that you complete an anger management course. I will sentence you as a first offender at your request. I find you understand the benefit as well as the risk of first offender. And I will not at this point agree to have your probation automatically terminate after the completion of anger management. But if you get deep into your term of probation and you can convince probation that things are going well, they can always ask me to end it early. But the trigger won't be that you finish the anger management course. Mr. Peoples, anything else on behalf of the state?
No, Your Honor.
Ms. Nelson, should Mr. Hippensteel stay here because misdemeanor probation is on its way, or do you want to work through his lawyer?
I'll work through his lawyer. I'll send him the information.
Okay. Mr. Hippensteel, Mr. Doherty will be letting you know how to connect with misdemeanor probation. And you'll need to, whether it's call them or meet with them, but whatever the instructions are, you'll need to follow those. Okay.
Okay.
Mr. Doherty, anything else?
No, Your Honor, we filled out the plea form with the court like that.
I would. That would be great. You can give it to the deputy and we'll take it from there.
All right. And there's only a matter if I may be excused, Your
Yep.
Honor.
Thank you, sir.
So you have next one.
I think she's there. So that's open to her. Okay.
Ms. Rivers, there's a little bit of email traffic going that says that the sound system is working a little more consistently. Have you found that to be the case?
I did, yes.
Okay, I don't know what they did, but that's good news. Okay, we have 4 cases left that are maybe pleas. We can take them in whatever order. I don't see Ms. Wood here, so Ms. Feely, if you're ready, we could take your client.
All right, she's position 2 and her name on there is no longer correct. It's Miss Irvin.
Right. Ms. Irvin is what I knew her as, but that was at her request, and I want to make sure we use the legal name, but we'll work with Ms. Irvin. Is that with an E or an I? Yeah, that's what I thought. All right, Ms. Irvin, come on up. Mr. Peoples, you're welcome if you want to boot Mr. Jordan and sit in the middle there to sit, but you can sit up here too, wherever you're more comfortable.
Thank you, Your Honor.
I guess it's easier here because then the defendant's looking at you.
Right.
Are we good?
Yes, sir.
Okay, this is position 2 on our calendar, 21 SC 179365, State versus Shantisha Irvin, ERVIN, although on the indictment it's Ogbamudia. I'm sorry if I mispronounced that. Ms. Irvin, are you ready to go forward?
Yes, sir.
Okay. In a moment, Mr. Peoples will put you under oath. Make sure you listen carefully to his questions and answer them completely. And also, please make sure you tell Ms. Feely or me if you've got any questions. All right, before we go any further, Mr. Doherty, was there anything else?
Yes, sir. His phone was seized at the time of arrest, and he was interested in the procedures of trying to get that back. Should he work directly with the police department? Because none of the officers are there, so we're not quite sure who to reach out to.
So you may want to confer with one of the public defenders here, but there's a pretty standard order they submit to me that then you or your client could present to the Atlanta Police Department saying, in this case number, this was seized, need to give it back. The Atlanta Police Department will be focused on their case number rather than the indictment, but that ought to be in discovery. But that would be something I'd get from you if you want me to sign an order. They ought to give it to your client, and his disposition would show that, but that's not going to have the Atlanta police number on it or anything like that. So plan.
I'll prepare a word, send it to you.
Okay.
Thank you, Your Honor. Sorry for the interruption.
No problem. Okay, back to Ms. Irvin.
Will you raise your right hand? You solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can lower your hand. Please state your true, correct, and legal name.
Shantisha Odebito, SHANTEISHA OGBEMUDIA.
Thank you.
You're welcome.
Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you?
39.
I'm sorry?
39.
39?
Yep.
And what is the highest level of education that you've completed?
10th grade.
Do you have your GED?
No.
Are you able to read, write, and fully understand the English language?
Yes.
You understand that you're charged with the following offenses. Count 1, forgery in the second degree, which carries a sentence range of 1 to 5 years. And count 2, obtaining or attempting to obtain dangerous drugs by fraud, which is a misdemeanor, which carries a sentence range of up to 1 day, up to 12 months.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges.
Yes.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial.
Yes.
Had you have enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a sentence of, Your Honor, we'll be asking to null pros count 1. And the sentence would be 12 months probation and a stay away from the address to be named shortly. Do you understand that?
Yes.
You understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes.
Do you understand that if the court orders a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty?
Yes.
Do you understand that if you're placed on probation of any kind, that you cannot violate the criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Are you a citizen of the United States?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand these rights?
Yes.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No.
How do you plead to count 2, obtaining or attempting to obtain dangerous drugs by fraud?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself?
Yes.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on May 26th of 2021, law enforcement responded to Walgreens at 4395 Kimball Bridge Road, Kimball in Fulton County on a fraud call. They met with the pharmacist, Kancharla Raghu, Kancharla Raghu, Raghu, who provided 2 prescriptions issued for Eunice Irvin, one for oxycodone and the other for cyclobenzaprine. They stated that they'd received a notification the other day regarding Ms. Irvin and there being attempts to pass fake prescriptions in that name. Law enforcement located a female outside of the store matching the description given by the pharmacist. They asked her questions. They spoke with her and she was identified as Ms. Shantisha Ogbemudia.
Yep.
I do apologize if I
Fine.
mispronounced. They spoke with her. She was traveling with another individual in a white Chevy Tahoe. Ms. Ogbemudia stated that she had met with a woman at a Wendy's in Alpharetta and offered to pay them to pick up the prescriptions for her at Walgreens. Upon further questioning, she stated that she needed to make some quick money, met with the female at the Wendy's in Alpharetta, who showed her a Georgia ID identifying her as Eunice Irvin, and told her that the prescriptions were real. Counsel, do you stipulate there's a factual basis for this plea?
We do.
Thank you. That's all from the state, Your Honor.
Thank you, Mr. Peoples. Ms. Jackson, do you have any criminal history information?
The defendant has 4 cycles. The defendant's last arrest was January the 27th, 2023 in Cobb County for forgery in the first degree, 2 counts. and 2 counts of possession of controlled substance. There was no disposition for that arrest. The defendant does have a misdemeanor sentence and a conviction. When in 2004, the defendant received a no contendere sentence out of Clayton County for 4 counts of deposit account fraud. Then there was one in 2003 out of Covington, Georgia, for theft by shoplifting. Nothing in addition, Your Honor.
Thank you, ma'am. Ms. Feely, what's going on with the Cobb case, if you know?
I don't know that, I don't believe it's, I'm not sure.
Okay. All right. What do you want to add?
I know you know Miss Irvin perhaps better than I do, but as you heard, she's 39 years old. She's got a now 12-year-old son.
She does.
Who her relationship with is very important. He lives with her. She does have stable housing. She's been working with a cleaning service at the airport since leaving drug court. And while she did not successfully complete drug court, she tells me, and she may want to speak on this some more, that she learned a lot.
She really liked the judge.
And she loved the judge. And she uses the tools and still uses the resources that she gained through her year at drug court. So she entered May of last year and was terminated, but has obviously drug court is more intensive than misdemeanor probation is going to be, but she definitely has put this situation behind her and is ready to move forward.
Great. Ms. Irvin, how's your son?
He's doing good. Well, he have his ups and downs with the passing of his sister. So, you know, that is, he loved first day. He loved the school because he's in 7th grade now. So
Good.
he's doing good.
Good. Where's he going to school?
The same school, Crawford Long Middle.
Okay. And was that the one you were trying to get him into, or you were trying to get him?
I was trying to get him out of that one.
Okay. And that's still not successful.
No, because he's on a waiting list for another school. So I'm hopefully, I got my fingers crossed that they call back because I don't like the school.
Okay. Well, good luck with that. And this job that you've got, how did you get that?
You know, when I was in drug court, it's the ABM. I did it through Indeed.
Mm-hmm.
So I actually started working with them part-time right after I left drug court.
And are you now an employee through them, or are you still through a temp agency?
No, with them.
Great. How many hours a week?
8.
8 hours a week? That's not so many hours. So was it like one day a week, or it's just a few hours?
Maybe I do Monday, Tuesday, Wednesday, and Thursday.
So you do 4 days a week, but it's only 2 hours each day?
It's an 8-hour shift.
Oh, so it's
going from 6:30 to 2:30 to 3 o'clock.
okay. So you're doing 32 hours a week.
Yeah.
Good. I mean, that's more money for
I'm
you. All
doing
right. So
good.
it's almost full time. 1 day short of full time.
Yeah.
Got it. Okay. Eunice Irvin. Who's that?
That's the lady that I met at the Wendy's.
It's just a coincidence that she's got the same last name as you?
I mean, it's a lot of Irvins.
Okay.
Yeah.
It's a small world.
Yeah.
Okay. All right. Ms. Irvin, not Eunice, but Shantisha, I find there is a factual basis for your plea, that your plea is knowing and voluntary. So I will accept it. I will follow the recommendation and sentence you to 12 months probation on the misdemeanor offense of obtaining dangerous drugs by fraud. You'll need to stay away from that Walgreens in Johns Creek, but that should be easy. You don't live in Johns Creek. You live far from
I
there.
told you I was going. My husband used to live out there, so we divorced now, so no reason for me to go.
Have you legally changed your name to Irvin now?
I'm working on it. They want $241 to change my name back.
They do, but you can fill out a pauper's affidavit if your income is low enough.
I don't like my name.
Well, you can look at filling out a pauper's affidavit, and then they waive the court cost. And it sounds like you might qualify for that. But in the meantime, you're going to have 12 months misdemeanor probation, and the main condition of that probation is that you stay away from that Walgreens, which will be easy for you. Mr. Peoples, can my staff sign the indictment for you?
Yes, Your Honor.
Ms. Feely?
Yes, Your Honor.
And Ms. Irvin, is it all right if we sign your name?
Yes.
Okay. Ms. Feely is going to get you the misdemeanor probation contact information. So you don't have to wait around today. But you'll either need to call or go in, and there's going to be a particular time when you need to do that. Do it, because if you don't, then they take out a warrant and I sign it. and I know, you ain't trying to do that.
So can I ask you a question?
Yeah,
So the time that I was in drug court, can they use that towards my probation time?
that's a negative.
Okay.
Nice try.
I tried.
I know. And it's a good question to ask, but no, ma'am. I think that got factored into the way the state handled your
Okay,
case. It's an
that's
older
fine.
case and you've addressed, it also sounds like the storyline here wasn't that you were getting the oxy, you were getting the money to get the oxy for
Yeah.
someone else.
Yeah,
Whether they were using it or selling it, not your business.
Yeah.
And frankly, while I worked with you in drug court, it really was more about giving you structure than it was about your
Work,
sobriety.
because I still contact the people in drug court. I call them. I actually gonna go see them today when I leave here. So
Good. Roll on by Hopal. They'd love to see you. All right. Ms. Feely, anything else on behalf of your client?
Yeah.
Mr. Peoples? Done. Thank you.
thank you. Okay, thank you.
All right. I think what's left is the Ms. Wood show. So tell me if there's a particular order. I know all your clients want to be seen first. Should we deal with our trucker?
Yes.
All right, Ms. Bradley, it looks like you're parked. Looks like you're holding your head in pain. Get you prominently on the screen here. There you are. We'll get Ms. Wood on the screen. Excellent. We've got the folks we need. I don't want to ignore our prosecutor there. We'll add him too. Okay. Let me just check one thing before we get started. Nope. All right. Ms. Bradley, you ready to go forward?
Yes, sir.
Okay. You are position 1 on our calendar. It's 20 SC 174253. And Ms. Bradley, I need to cover a couple things with you. One, and then Mr. Peoples will take it from there. You are somewhere on the road driving your truck. You are not here in the courtroom. Do you waive your right to be present in court with everyone else?
Yes.
Where are you?
I am in some part of Arizona. I'm in Arkansas. I can't tell you the name. I just drive.
Okay. But you're in Arkansas right now.
Yes, sir.
How's it looking in Arkansas?
It's raining.
Raining. Well, okay. Good. You're off the road. Number 2, Ms. Bradley, you have the right to have Ms. Wood right next to you so you guys can confer and discuss as you might need to. But Ms. Wood is not in Arkansas. Have you ever been to Arkansas, Ms. Wood?
No, Your Honor.
She's never even been to Arkansas. Do you waive your right to have Ms. Wood by your side for this plea?
Yes, sir.
Okay. If at any time you want to talk to her in private, let me know. She'll step out of the courtroom. She'll call you on the CB radio or whatever you use and in private. Okay.
Yes, sir.
All right. Sounds good. Mr. Peoples, when you're ready.
Yes. Are you able to hear me?
Yes, sir.
Thank you. Can you raise your right hand? You solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can lower your hand. Will you state your true, correct, and legal name?
Cadariums Centrez Bradley.
Can you spell it?
Kite, Alpha, Davis, Alpha, Rich, Igloo, Mary, Sam. Last name is Bravo, Rich, Alpha, Davis, Larry, Igloo, Y.
Why isn't the right?
Thank you. Are you at this time taking or under the influence of any drugs, medication, or alcohol?
I take Victoria for HIV.
Okay. Does it affect your ability to understand this proceeding?
No.
How old are you?
27.
And what is the highest level of education that you've completed?
Some college.
Okay, so then are you able to read, write, and fully understand the English language?
Yes.
You understand that you're charged with the following offense, count 1, aggravated assault, which carries a sentence range of 1 to 20 years, and count 2, aggravated stalking, which carries a sentence range of 1 to 10 years.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges?
Correct.
Is that a yes or a no? Do you
Yes,
understand?
I'm sorry.
Okay, I'll ask it again. Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes,
You plead not guilty or remain silent, that you may receive a jury trial.
yes, sir.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes,
Do you need any more time to discuss this case with your attorney?
no,
Are you satisfied with their services?
yes,
Counsel, do you waive formal reading of the indictment?
So wave.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
You understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a sentence of, Your Honor, we'll be asking for count 1 to be reduced to disorderly conduct and count 2 to be null prost, 12 months of probation and a stay away from the location to be named shortly.
Stay away from a location and also from Mr. Daniels, or just the location?
Both.
Both, okay.
Do you understand that?
yes, sir.
The court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, sir.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have the right to withdraw your plea of guilty?
Yes, sir.
You understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
And that you are not allowed to possess nor use a firearm while on probation?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney in the trial of your case, the right to the presumption of innocence, the right to testify in your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal a convicted of these charges after a trial. You understand all these rights?
Yes, sir.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Your decision to waive these rights and enter a guilty plea because you are in fact guilty.
Yes, sir.
How do you plead to the charge of disorderly conduct?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you
Freely.
and voluntarily?
No, sir.
So let me get in the mix here. Those are all synonyms. Freely and voluntarily mean almost the same thing. Maybe for legal reasons, the district attorney's office, both. I need to make sure, Ms. Bradley, that you are going forward with this misdemeanor disorderly conduct plea of your own free will. No one's forcing you to do it. You may not be excited about it. That's not the test, excitement. It's that there's no coercion, that no one is saying, if you don't do it, you're in trouble, we're going to hurt you, or this or that, but that you, after thinking about it and talking with Ms. Wood about it, and anyone else you want to talk to about it, that you decided this is the right next step for Ms. Bradley, and no one is forcing you or threatening you in a way that makes you do it.
Yes, I'm freely doing it. And it's Mr. Bradley, my boy, my male. He keeps saying Miss.
I was told otherwise. I'll say it however you want me to say it.
But yes, sir, I want to take this plea.
Okay, so no one's forcing you to do it. This is what you're doing because you think it's the right way to get this behind you.
Yes, sir.
All right, thank you, Mr. Bradley.
You are.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes, sir.
You understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, sir.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes, sir.
Do you understand that the filings that we've just discussed must be filed by your counsel unless you're representing yourself?
Yes, sir.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on November 23rd of 2019, law enforcement responded to a call at 1619 North Olympian Way Southwest in Fulton County. They met with Randy Daniels, who advised that he and his roommate, Stanley Jones, had an active restraining order that states they are not to be within 10 feet of each other. Mr. Randy Daniels has had an active restraining order against Mr. Kadarius Bradley, who is not to be within 200 yards of Mr. Daniels. Mr. Daniels, Mr. Bradley was seen at that location at 9:36 a.m. that day.
So Mr. Daniels had a restraining order against both Mr. Jones and Mr. Bradley.
That's my understanding.
Okay.
It was a little bit confusing, but that's
Yes,
my.
sir. It's correct.
Got it. And the allegation is that both Mr. Bradley and Mr. Jones had contact with Mr. Daniels.
That's correct, Your Honor.
Okay.
Mr. Daniels stated that Mr. Jones pushed him and scratched him in his chest at that time. And Mr. Daniels wanted Mr. Jones to be taken into custody. Mr. Daniels had asked law enforcement to relocate to the Popeyes where Mr. Bradley was working at that time, and he was taken into custody there. Your Honor, the age of this case, as well as initially 88 Cassie Hall was going to be working on this case. And I've been working to try to locate the victims on this in some time. I spoke to 88 Long when I came in this afternoon, and she had the same issue, that they've been also unsuccessful with finding the victim in this case. So along with that, so those evidentiary issues, as well as the age of this case, we believe this is an appropriate resolution.
Okay. Ms. Jackson, do you have any criminal history information on Mr. Bradley?
Yes, Your Honor. He has 5 cycles. The last arrest was April the 16th, 2023 in Louisiana for criminal damage to property. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
Thank you so much. Mr. Bradley, I don't want you to go into the facts or the allegations of that Louisiana case, but that's not all that old. Is that still open? Do you know?
Court date is August the 18th for a disposition.
Got it. So in 9 days, you'll be in court in Louisiana?
Yes, sir.
Okay. All right. And disposition as in you and a lawyer have worked it out, or what is it that you think is going to happen on the 18th?
18 is me and the lawyer had worked it out. It's see before the judge to get a dismissal.
Okay. All right. Ms. Wood.
Thank you, Judge. As Mr. Peoples stated, this is a very old case. I think there's probably more to it. I think it's a rooming house situation. I know that Mr. Bradley will not have an issue staying away from Mr. Jones or Mr. Daniels. He actually contacted our office when he realized that there was a warrant for this case. He moved on. After this happened, he left the state. He has been back to Georgia. That is one reason that he was eager to resolve this so that he could move forward with his life. He just got his job as a truck driver. And so He is hopeful that you would accept the state's recommendation, and he did want me to ask the court to consider suspending his probation upon a period of good compliance, Judge.
Okay. Mr. Bradley, anything you want to add to what Wood just said?
One thing I do want to say is that I was contacted by Mr. Jones. His lawyer was trying to get in contact with me due to the fact that after reviewing Mr. Daniel's case and his files, that they was told me to tell Ms. Wood, to inform Ms. Wood that Randy Daniel is an unreliable witness because his arrest record. Since that day, I left. Even when after the first court date, I moved that night. I waited at the bus station, slept in the cold that night. So as far as him reported seeing me, that wasn't true. As far as him saying that I was arrested at Popeyes, that wasn't true. I quit my job that night. Since then, I couldn't get treatment. I couldn't do nothing due to my HIV situation. I couldn't get treatment. I couldn't do nothing because of the time lapse of trying to get a medical records transfer from Georgia back to Mississippi.
Are you staying in Mississippi now, or are you staying in Louisiana?
I live in Mississippi.
Okay, so this case in Louisiana, that's just something that happened while you were on the road.
Yes, sir. That happened while I was on the road.
Okay, and how long have you been driving the truck?
I've been driving trucks for 2 years, touch every state, touch all 48 connecting states in 1 year, my first year driving.
That's a lot of driving. Okay. So the last time you heard anything about or from Mr. Jones or Mr. Daniels would have been the day after you got arrested and bonded out.
I've never been arrested. I never got arrested. Never went to jail in Atlanta a day in my life. Never did anything. That's what I'm saying. After that night, after the first judge told me that I had to move, I moved. I got on a plane. I got on a bus, a Greyhound bus that night in Atlanta, and I took that bus to Jackson, Mississippi.
Was that back in 2019 when this happened, or was it in
2019 when this happened? Now, me and Mr. Jones, we are best friends. We are close. We communicate all the time. Mr. Jones had to deal with the same situation, but in a different manner. And recently, back maybe 2 or 3 weeks ago, he inboxed me and said it's completely over with him. Him and his lawyer had his case was completely dropped due to the fact that Mr. Randy Daniels was an incomparable, reliable witness because of his arrest records and his police file.
Where is
The whole time I stayed there, sir.
Where is Mr. Jones these days? Is he still in Atlanta or is he somewhere else?
Yes, sir. He's still in Atlanta. He's finally got his house back. He finally got all the stuff that was taken. Finally got back on his feet to do what he was supposed to have done the first time, get his head above water.
Okay, got it. Well, Bradley, I find that there is a factual basis for your plea to disorderly conduct. I also find that your plea is knowing and voluntary. I know you were a little reluctant with that word voluntary, but I do find that you are entering this plea of your own free will. No one's forced you to do that, and that you've understood all the things we've talked about. Do you agree with that?
Yes, sir.
Okay. I'm going to sentence you, Mr. Bradley, to 12 months, but I'm going to suspend the 12 months. You live in Mississippi. You're an over-the-road trucker. And so having you supervise for a few months in Georgia doesn't make a lot of sense. But I am going to impose a condition on your suspended sentence, and that is that you have no contact with Mr. Daniels. So if Mr. Daniels reaches out to the police or the district attorney's office and shows them a text from you or something that is somehow evidence that you've been trying to contact Mr. Daniels, the prosecutor would be entitled to reopen your case and have me revoke some of that suspended time. And if the state can prove up that you were reaching out to Mr. Daniels for good or for bad, I might well revoke some of that suspended time. So if you just keep on trucking and doing your thing and maybe don't do whatever you did in Louisiana in April, then you don't have anything to worry about back here in Georgia. Does that make sense?
Yes, sir.
Okay, so it's 12-month suspended sentence. There is a condition of no contact with Randy Daniels, and we will leave it at that. Mr. Peoples, anything else on Mr. Bradley's case?
Yeah.
Ms. Wood?
No, Your Honor, thank you.
All right, Mr. Bradley, you can start driving again.
Okay, thank you. Y'all have a blessed night.
Too. Bye-bye. Was there some point when someone said, not today, Ms. Bradley?
Yes, Judge.
Okay. I apologize for messing it up today. And Ms. Nelson even sent something earlier today saying, hey, it's Mr., but I misread it. And like, right, I know, I forgot it's supposed to be Ms.
I understand, Judge. Thank you.
My bad. He'll be all right.
We can do that one. Mr. Neal, we can do the final plea hearing for Mr. Neal, Judge.
Oh, okay.
Judge, can I have a super for a second?
Sure. I'm sorry, what? Yeah. Yeah, it is. And I think all the lawyers are quitting from the case. Well, Glanville needs to say continue. If Glanville says continue, I'll take it off.
No.
Yeah. Who?
Not this last one. Girls can have 5, please.
Oh, Lord, yes, yes, you do. Yeah, no, that's well put. But yeah, the way I work it is someone will say, hey, there's this issue and it looks valid to me, but I don't make the decisions for the other ones, but it needs to come off because those lawyers, I saw that hit the docket the moment the calendar came out. So that guy's got, is he out on bond? In custody.
He's pled guilty to the RICO YSL.
Oh.
He reoffended and they were about 10 years.
Oh, so Judge Glanville is that why he got YSL? Because of this 10SC case, or he has the 10SC case because of YSL? EBD.
I think it's the 10SC case. The reason why.
Okay. Yes, contact His Excellency. And they just need to shoot me an email saying it should be continued, and then I pull it off and Emerson won't worry about it. But I figured that was what was happening.
Thank you very much.
Sure. Mr. Neal, I'm sorry. So let's get on the record with position 3. It's 23 SC 186913, State versus Charlie Neal. Mr. Neal is seated at counsel table with his lawyer, Ms. Wood. Mr. Neal is charged with aggravated assault and possession of a firearm during the commission of a felony. Ms. Wood, do you have all the discovery that you think is out there in this case? All right. And more importantly, you're ready for trial?
Yes, Judge.
All right. Mr. Peoples, what is the state's recommendation if Mr. Neal wanted to resolve his case by way of plea today?
Your Honor, the state's recommendation would be 5 years probation, anger management, no violent contact with the victim. I'll sell it in just a moment, and a weapons forfeiture. The victim's name would be Miss Adriana Hayes.
Okay. Mr. Neal, do you understand that if you were to enter a plea today, I guess the way you do that, would you dismiss count 2? Because that's 5 years consecutive.
We would ask that it would have been suspended.
Suspended. So it's actually 10 do 5. Well, it's 5 years probation followed by 5 years suspended.
Correct.
Okay. All right. Mr. Neal, if you were to enter a plea today, the state would recommend a sentence of 5 years probation followed by 5 years suspended, with the main condition being stay away, no violent contact with the alleged victim in the case, and a couple other conditions. Do you understand what the state would recommend?
Yes,
If not, tell me, I'll explain it better.
I understand what they mean, but,
Okay, my question right now is, do you understand it? Not, do you like it? Do you want to buy it? You understand it?
yes,
Yes, okay. You also understand that Ms. Wood, if you entered a plea, could recommend a lower sentence. It could be less probation. You can't get a whole lot lower. It could be fewer years of probation, but she could recommend fewer years of probation. You understand that? And if I were to sentence you to anything more than what Ms. Wood asked for, let's say she said 2 years probation, Judge. If I sentence you to anything more than that, today you could back out and say, I was willing to do 2 years probation, but not 3 or 4 or 5. Understand that?
yes.
After today, you may decide you want to enter a plea. I may not agree with what Ms. Wood recommends, but if I sentence you to more than what she asked for, you do not get to withdraw your plea after today. You understand that?
Yes.
Okay. Ms. Wood, have you had a chance to speak with Mr. Neal about the state's recommendation?
Yes, sir.
Is Mr. Neal interested in resolving his case today, given the state's recommendation?
No, Your Honor.
Okay. We'll move the case to the trial calendar and we'll see how it evolves. Anything else on behalf of Mr. Neal?
No, Your Honor.
Mr. Peoples, anything else?
No, Your Honor.
So, Mr. Neal, we'll see you on September 20th if the case hasn't resolved before then, okay?
Sure.
All right.
Judge, I believe that concludes my business. May I be excused?
You may. Before you run away, what do we have tomorrow? We've got a couple hearings. Are you involved in either of
I
those?
believe we have a motions hearing for Marcus Ware, Your Honor. That's going to be a plea.
Okay. He's got a co-defendant.
He does. I've reached out to, I believe, counsel is Joe Brown, Joe Lewis Brown.
Yeah.
I've reached out. I haven't heard back.
Well, he'll see what happened to Ware and maybe that'll move that one.
It will.
Judge, I'm sorry to interrupt. I do believe the council wanted to come in at 11 to take that plea tomorrow. Is that still your intent?
Well, we have a hearing at 11, which is the motion to withdraw a plea / resentence in Mr. Reeves's case.
Okay, so I guess we'll leave it on at the scheduled time then.
I'm happy to move it around, but you have something on our calendar at 11 for Reeves, and Reeves will be zooming in from DOC.
Correct. I just didn't know if you wanted to take their plea after that, but we can leave it in the afternoon.
We could totally do it because that Reeves thing won't take long. Do you want to do?
I would ask if we could approach for 2 seconds, just kind of off the record for a moment.
Okay. Since that's on, let's come over. Yes.
I think it be necessary for security this virtually. Is that possible?
Yeah, that's fine. My question is just when do we do it?
Oh, and I'm on the.
Yeah, that's fine. I was
Okay.
gonna be here because I think he's getting trained, Mr. Ware.
Oh, I asked.
Yeah.
But
so-
you just don't have to physically, be here, which is fine.
Yeah, that's fine.
But your day is open.
Correct.
Okay.
Yes.
All right.
I just didn't.
Perfect.
Okay.
Okay, all right.
Yeah, press that and go. Ms. Nelson, is Mr. Ware being transported tomorrow?
I'm a blank. I'm not sure, Judge. Let me check.
Okay. It's your calendar, but hopefully he is, because it was supposed to be a motion to suppress. And we can do it in the morning, which would be great. And we just need to make sure, I mean, I assume he'd be brought over at 8 in the morning anyway. And Ms. Wood would be here. You're not the motion to withdraw, that's Mr. Rafus from the Aurora firm, I think is representing Mr. Reeves now. I don't know who's going to handle it for the state. It thinks someone from appeals.
Probably so. That one's not on my radar, so but I can check.
Okay, well, if you just log in, there is a Zoom that you should have, and just log in around 11. And we'll go with whoever's first. If DOC is a little slow in getting Mr. Reeves, then we'll do Mr. Ware, assuming Mr. Ware is here. And are you going to be here or are you going to Zoom in? All right, so if you get here at 11, the Reeves thing should be pretty quick. It's not a new plea, it's just resentencing. And then we'll do Ware. And then you guys have your afternoon off from here.
Yes, where's going to be transported, Judge?
Excellent. Okay, so yes, Ms. Nelson, we'll move that to 11 as well. Now, one little caveat. I have jury duty on Thursday, but I'm group 2, and usually group 2 doesn't come in on Thursday. So I'll know tonight. I think I can call after 5. But of course, if I have jury duty and I get sent to a courtroom, civic responsibility comes first. And we'll have to cancel all that stuff. But I bet that's not how it will play out. So assume you'll be here at 11 virtually or in person. We'll have Ware and Reeves.
Thank you, Your Honor.
Excellent. So with that, let's do Mr. Washington. Are we able to do that now? Oh, because that was right. You were saying you wanted to go, and I said, let me see what's going on.
Yes, sir.
And you're going on, but you're going on at 11 tomorrow.
Yes, sir.
Okay.
Thank you, Judge.
And Judge, this is no longer a plea, it's just a final plea hearing.
Okay. Mr. Washington, come on up.
I'll wait on you. I'll wait on you.
I'm just getting Mr. Shapiro's information up. Not that I don't want to hear from you, Mr. Jordan, but this isn't what was forecast. All right. Let's get on the record with position 6, 23 SC 186964, State versus Adrian Washington. Mr. Washington is at counsel table with Ms. Wood. Mr. Washington is charged with burglary and 6 counts of aggravated stalking. Ms. Wood, are you in possession of all the discovery that you're aware of you should have?
Yes, Judge.
And are you and Mr. Washington ready for trial?
Yes, Judge.
Okay. Mr. Jordan, Mr. Shapiro shared with Ms. Wood and with me what he had as the offer if Mr. Washington wanted to go forward today, which would be a dismissal of count 1, the burglary, a period of 5 years probation for count 2, so one of the aggravated stalking counts, dismiss 3 through 6, 4 of the aggravated stalking counts, and then count 7 is another 5 years probation, but concurrent, so at the same time, it's another aggravated stalking. So the net of all that is most counts are dismissed, and Mr. Washington would be on probation for 5 years. He would need to have no more contact with a Samantha Washington and stay away from the location where whatever happened, allegedly happened. And there's a permanent restraining order, which is, I think some of the details needed to be negotiated. Is that what you have, Mr. Jordan, or is there a revised version of that?
That is what I have, Your Honor.
Okay. So, Mr. Washington, you understand that if you were to enter a plea today, the state would be willing to dismiss 5 of the 7 counts in your indictment. And for the remaining 2 counts, they'd recommend 5 years probation with some conditions that you heard me mention. Do you understand that that's what the state would do today?
Yes, sir.
Do you understand that after today, that this offer expires when you walk out the door, so nothing will be dismissed necessarily? The state could go forward to trial, and all those counts would be in there. I think aggravated stalking is 1 to 10 years. So that's up to 60 years in custody for all the stalking counts. You don't need to prove all of them. It's 10 years for any one of them. and the burglary would be 1 to 20 years. So it's a maximum sentence. If everything went really poorly for you, and I learned a whole lot about you during the trial, of 80 years in custody. Of course, if you're found not guilty at trial, the maximum sentence is 0 because you're found not guilty. But you are working with a case that has a range of 1 to 80 years in custody, depending on how it goes at trial. Do you understand that?
Yes, sir.
Okay. Understanding those things and knowing that today you could withdraw your plea if I sentenced you to more than what Ms. Wood asked for. But after today, you cannot. You can still plead, but you got to roll with whatever sentence you get. Do you want to enter a plea today or have this case go to the September trial calendar?
September trial.
Okay. You'll need to be here in court on September 20th. You'll get notice to remind you of that. And Ms. Wood, I'm sure, will be reminding you. But you understand now this offer is off the table. It may get better for you because there may be something about your case that the state needs to better appreciate. But there's no guarantee of that. And you don't, in particular, get to resurrect this offer. In other words, you come back on the 20th of September to say, all right, you know what, let's do this 5 years probation thing. Ms. Wood can ask for that, but Mr. Shapiro, who's not here today, could say, that was August 9th. I'm ready to go. If he wants to take 2 years in prison, let's do it. Otherwise, let's go to trial. And I'm making up that number of 2 years in prison. He would have whatever offer, but it could be a different one. It could be one you like less. You understand that?
Yes, sir.
Okay. Understanding all these things, Mr. Washington wants to at least say no thank you to this offer and go to trial. Ms. Wood, you'll let us know if between now and then something else works out.
Yes, Judge.
Okay. You don't need to answer, but I'm curious, is the hang up the permanent restraining order or it's more fundamental than that?
It's a little more than that.
Okay. And are the minor children Mr. Washington's biological children?
No.
Okay. So we're not getting into parental rights here.
No.
All right. Understood. And then Samantha Washington, I'm noticing the last name. Is that a relative, a former spouse? What is the alleged
Ex-wife.
ex-wife, former spouse? Okay. Mr. Jordan, anything you want to get on the record on behalf of the state?
Nothing further from the state, Your Honor.
You'll let Mr. Shapiro know you couldn't seal the deal.
Yes, Your Honor.
Okay. All right. Mr. Washington, do you have any questions?
No, Your Honor.
Okay. We'll see you in September.
And that concludes my business, Your Honor. May I please be excused?
You may. It actually includes everyone's business. So thank you, Ms. Jackson, Ms. Tucson. We didn't get any felony pleas today, so no felony probation. And we will see you all. It turns out that our motion tomorrow is going to be, okay, so we will need Ms. Tucson and someone from pretrial services, ideally Ms. Jackson, but if not, an able replacement, at 11 tomorrow. We're not going to do the afternoon calendar. We're rolling it into the 11 o'clock calendar. So hopefully we can get you guys here virtually at 11 a.m.
Thank you, Your Honor.
All right. Thank you, guys. Bye.